Hey y'all, I'm Karen Mayer Cunningham, the special education boss. If you've ever felt confused, overwhelmed, or just plain frustrated at the 504 IEP table, you are in the right place. Every week, I'm breaking down the rules, the rights, and the realities of special education so you can walk into meetings informed, empowered, and ready to make real change. And whether you're a parent, a teacher, an advocate, a school-based member, or somebody who's just trying to do right by a student, this podcast gives you straight talk, real answers, and tools that you can use immediately. I'm not here to play politics. I'm not here to play sides. I'm here to train people who sit at the table and teach you how to follow the law, ask the right questions, and protect the rights of students. So go ahead and hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change. We're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody. Special Education Academy. Thanks, family, for joining us. We are going to have a really interesting conversation today around dispute resolution options. So if we haven't met, I'm Karen Mayer Cunningham, Special Education Boss, training everyone that sits at the 504 IEP table to navigate, to negotiate successful student outcomes. Often in special education, which I don't think you necessarily hear in other entities, that, we have to build a strong relationship with the school-based members and that the parents have an obligation to work with the school. I had a podcast that I did last week that'll be coming out in a couple weeks. One thing that was said, which is really interesting to me, is the previous educator who I was interviewing, she said, teachers, and, riddle me this if you guys believe the same, teachers are taught to manage parents. Teachers are taught to manage parents, whereas they're also taught to manage children, right? And that's not the intention of special education. Special education is a federal requirement. It's a requirement since December 2nd, 1972, when Gerald Ford, our president, signed into the Educating All Handicapped Children Act. Of course, it was renamed in the 90s and then reauthorized in 2004. It's time for another reauthorization. Can we all say amen and agree to that? But this notion that school-based members have some understanding of the federal law, if you believe that, you are mistaken. So this is the federal law book. This is the Office of Federal Registry, Code of Federal Regulations, Title 34, Volume 2 of 4. Volume 2 of 4. Why is it Volume 2 of 4? Because IDEA is broken into 4 parts, right? It's broken into A, B, C, and D. A gives you good definitions. B talks about special education. C is infants and toddlers. And of course, D is information for research and also for professional development for special education for teachers. Does that ever happen? I rarely see that happen. So we live and die in special education in Part B, right? So Volume 2. If you don't have this book, go get this book. It's in our link above, or if you go to our website, Special Education Academy, and go to the bookshelf, which would be under training, you can get this book. You should have this book. And I love teachers. Teachers and special educators and paraprofessionals changed my son's life 100 years ago, which is why I'm in this process and in this space. But they're not trained on special education law. Certainly, if you were an educator or you have your special education certificate, there was some training in college or when you got that certification, but you were not trained on the 115 statutes in this book. You weren't. And so when we talk about teachers being nice to teachers and being nice to school-based members and being nice to parents, we have go into meetings and they read these meeting norms that will all be nice to each other and talk in a pleasant tone. I think that, it's frustrating for parents because sometimes the people that are in the meeting are trying to get through the process of the IEP meeting. They're trying to get through the process of finishing the meeting. And parents are trying to get through the process of getting their child services. But we're all bound by implementing IDEA with fidelity. And the only way that you can implement IDEA with fidelity is if you knew what it said. And 3/4 of the people that we train and that we're blessed to have on our podcast and our show and our trainings are school-based members. And you know why they're there? Is it because I'm so amazing? Maybe. It's because they're not trained by school districts. And so this notion that when we get into a meeting that we should all talk really nice to each other and be kind to each other, I don't disagree with that. I don't know about nice and kind. I certainly know about professional and ethical. But when we're asking for the school to deliver baseline for kids with disabilities, to deliver the IEP, it's frustrating for parents sometimes that we come to disagreements, right? And so I want to talk today about what your dispute resolution options are. Hopefully you never have a dispute in special education, but to disagree with people, to disagree with other humans is part of the human experience. I don't know why we think it's so odd that it occurs in special education. So today we're going to go over what are our dispute resolution options, meaning if you disagree with the school district as the parent, as the guardian, as the surrogate parent, what are your options? And really, what is the best option? So I am a non-attorney special education advocate of 28 years. So I've handled hundreds of these at the federal level, at the state level, mediation, state written complaints, and even represented families all the way through the due process hearing process. And so we're going to talk about kind of the 4 options to resolve disagreements in special education as it relates to your school district, your city, your county, kind of what they mean and how much weight they have, right? It's important that when you choose your dispute resolution option, that you choose what's the best mechanism for you at the time. Why? Because you get to file how many times? One. And so we want to make sure that we're choosing the right one. So this is just going to be kind of an overview, but you have the options. Your state DOE, your Department of Education, your state SEA, Special Education Agency, will have more information as it relates to your state. They have these forms available. So let's kind of go over them really quickly, what the 6 are. So the number 1 is a district grievance. Let me just help you right here. All right, is this thing on? Are y'all listening? District grievance. Don't waste your time. Don't waste your time. I have never, ever in 28 years seen a district grievance do anything but irritate the family. They're sent from one person to another person, and nothing ever gets done in all the ones that I've participated in. The next one's a state IEP Facilitation. Number 3 is mediation. I'm a certified mediator for the family courts here in Houston and Fort Bend and Harris County. So I think mediation is a great mechanism. A state complaint or a due process hearing, or of course a federal complaint with U.S. Department of Education Office of Civil Rights. So today we're going to talk about the state ones. We'll talk about the Office of Civil Rights at another time, but I want to talk about your state options. So dispute, that is when 2 people see things differently. We see things differently, right? So the state IEP facilitation. So this is sort of new to most states. It's a great mechanism. Sometimes we just get to a place where we cannot agree on a component of the IEP, whether the component is testing or the present levels or the annual IEP goals, or as we all often get disagreement, the placement or programming for a student. So what is the purpose of the state IEP facilitation? So it's used when a parent or a school cannot agree in an IEP meeting on important issues related to a student's IEP when a meeting expected to address difficult issues. I would say that these meetings are difficult meetings. Why? Because we have school districts that use their school district budget, sometimes not as focused on special education students. Sometimes school districts do not use their special education funding for special education students. It goes to somewhere else, which is something that we're working on at the state level and the federal level to have an enforcement mechanism. A special education money from IDA is a grant. It's a federal grant. So every year, your school district writes a letter to Congress, and you can look at your state's ranking in that report to Congress annually. And it says, "Dear Congress, we are Texas Education Agency. We are going to be able to fulfill our commitments under IDEA in Texas to our 775,000 students that have an IEP, and we're going to meet those obligations." And so in return for that letter, they release federal funding to the state. And so it's greatly concerning for me, and we are working with legislators and representatives at Capitol Hill and DC to work on getting a bill passed for an enforcement mechanism. And what does that mean? If you don't use the money for the special education students, then there is a consequence, right? And that we're certainly going to work on one at the state level, that if you don't use those funds for special education students, there are levels of sanctions, which we just had come out in House Bill 568 in Texas. So we're working on those at the federal and the state level. So who can request the IEP facilitation? The parent and the school sign a form requesting IEP facilitation. When and why can it be requested? The request for the form must be filed within 10 calendar days of the IEP meeting that ends in disagreement. These are specificity to Texas. They're different in every state. So that means that we have to come to a disagreement. So for me, I'm a little reticent to use this dispute resolution option sometimes for my families. And why is that? Well, because when you disagree legally twice with a school district's proposal of FAPE, an offer of FAPE. And when does the offer of FAPE come in an IEP meeting? The offer of FAPE in an IEP meeting only comes when we've talked about the schedule of services page. So if you've ever been in an IEP meeting and the principal or the IEP lead said, well, we have to sign and disagree, we're in disagreement, and you're still in the present levels, don't do that. Don't sign a disagreement. There hasn't been an offer of FAPE. Or sometimes you're in disagreement with IEP goals and they say we have to sign a disagreement. Make sure that you understand your legal rights and are not depending on somebody who understands policies and practices which may not be legal under state and federal law. Okay? So that means you must have come to a disagreement. Remember, unlike you've been trained by some other lovely people in the special education world, sign the IEP paperwork. Why? Because it captures your position. When you don't sign the IEP paperwork for whatever reason, that person that's going to see that at the state level, a state mediator, it might go to a due process hearing at some point. It might end up going to a federal complaint. All they have is the paperwork and you didn't sign. When you don't sign at all and have not captured a position, it looks like you didn't participate. And we don't want that. We want how we participated, how we felt about what occurred in that meeting, our recollection of what occurred in the meeting. I know you guys have been in IEP meetings and we've had some nice lady or some nice man taking deliberations. And then when you get the prior written notice or the case conference notes or the deliberations, that didn't happen. That's not what happened, but you didn't capture your position. So please don't listen to people that say don't sign. That is silliness to me. Okay. Is this kept confidential? The same laws that apply to protect confidentiality of a student during an IEP meeting apply during the IEP process. Here's what's important to know. What applies in IEP facilitation is not sealed. It's not confidential. And so we'll get into that in the next one. So one entity that is confidential is going to be mediation. We'll talk about that next. So I've had lots of IEP facilitation meetings that were fantastic. They're usually very, 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 very nice people from the state, very calm people. They do give each party an opportunity to finish their thought, their input. Often when you get in a disagree, we just end up talking over each other, and sometimes people say things that aren't so nice because you're worn out and your feelings are hurt and it just kind of slips out. So the IEP facilitator certainly reminds each parties of their duties and obligations, but they don't make a decision. They are not a state attorney. Even if they are a state attorney, that's not their role there. They're a vendor for the state that's come in to try to facilitate a better level of communication. They help you walk through all of the components. Often they will call both sides before the meeting and say, hey Karen, what's going on here in ABC school district? And then they'll call ABC school district. And of course, each person has a different purview of what existed. And so often I've had IEP facilitators that have spoken with myself and the parent afterwards and said, I would recommend that you continue triggering your procedural rights and safeguards, right? That you invoke them. I always say that you have legal rights, but if you don't invoke them, it doesn't really matter. And so also at the state level, and I work with lots of amazing state education agencies, if you don't complain legally through their dispute resolution options, the state never knows. So if you're having problems in, Wichita, Kansas at a school district, and I'm just making this up, and you don't let the state know, the state doesn't know. The school district is not going to call the state and go, listen, we are doing a bad job. We are having a bad time with this family in ABC school district. It's not that way. It's like a franchise. They're not going to report to corporate what's going on, good or bad. If you don't let the state know that there's a problem, that there's a systemic problem, that there's an ongoing problem, there's a failure to implement FAPE, there's a failure to implement the IEP with fidelity, there's a failure to write appropriate annual goals, there's a failure to identify the student's unique circumstance and write an IEP to enable him to make progress, the state will never know. You have to let them know this. And one of the ways that you let them know this is triggering your dispute resolution options at the state level. So dispute resolution options at the state level, again, are an IEP facilitation, mediation, a state complaint, or due process. So a district grievance, the state never knows about that. They never know about that, okay? All right, so what is our next option? So our next option is mediation. And you don't have to do these in this order. I'm just going through them so that we can kind of understand what they are and what they're for. So mediation. So I am a certified mediator for the family courts. They have, there's very specific statutes around that at the state level, whatever kind of mediation you're participating in. But if you're participating in mediation for IEPs, then it may be used at any time. The parent and or the school district cannot agree about a student's special education and or related services. Who can request mediation? A parent or school district may request mediation in writing. So the mediation request goes to the state, and you have to notify both parties. When and why can it be requested? It can be requested at any time. Anytime there's a dispute about a student's special education eligibility, services, including before or after a due process hearing or a state complaint. So I can request a mediation at any time. I can request a mediation if I literally am struggling to work with this school district. Sometimes you get into school districts and the person in charge is sort of, for lack of a better word, just dug in their heels, right? It's just they come in on no, they leave on no, and it's just walking through mud to get anything done in a school district. Here's what you know. Mediation is voluntary, right? So mediation is voluntary. So if I, as a parent, file a mediation, ABC school district can choose to participate or not participate. If ABC school district files against a parent for mediation, the parent can choose to participate or not participate. It's completely voluntary. So I can tell you that I certainly can't discuss what happens in mediation, but I think it's a very good mechanism to be able to get all sorts of issues on the table in a smaller setting that is more private. Is it kept confidential? So discussions during a mediation are confidential and are not subject to release. Settlement agreements are subject to release with identifiable information release. So let's talk about that. So if I'm in a mediation for, let's just say I'm in a mediation at a family court and I sold somebody my fishing boat and they owe me $5,000. And the court says, Harris County in Houston says, I need y'all to go to mediation first. Whatever happens inside of that mediation with the certified mediator, with my party and the other party, whether it's 2 hours or 2 minutes or 2 weeks, is completely confidential. If there's an initial offer, if there's an offer of money, if there's an offer of service, all of the things that happen in between are completely sealed. Okay. And what does that mean? That means at the end of the mediation, you shouldn't have any notes about it. Most mediation officers will ask you to tear up your notes. And additionally, that mediation officer cannot be called into a due process hearing as they have no record of the meeting. And so what usually happens in a state mediation for education is that we will agree to mediation. I will go with my client. We will log on at 10 in the morning. We will talk to the mediator about our position and why we filed mediation. I will have my client give tell the mediator what happened to them, how long this process has been, how arduous this process has been, and then I will say what the legal components of are, okay? And then that mediator will go into another breakout room with the school district. You are not together, hallelujah, right? Because we probably weren't doing so well being together before anyway. So you're not together in the mediation, which is great. So I can say whatever I need to say to the mediator. You can say whatever, the school can say whatever they need to say to the mediator. And so the mediator goes back and forth. And, if the mediator is in the other room with the school for a long time or a short time, it doesn't really tell you if things are moving forward or not moving forward. if you're going to be able to come to a settlement in a mediation with the school district, then they're working with an attorney to get that paperwork written up. So I've had great mediation offers. I can say in all these years of doing mediations with school districts, I can't think of a time, except for one, I can't think of a time that the school district didn't at least have an offer for the family. It might not have been a good offer, it might not have been a great offer, but there was something offered. So I don't find that school districts do this to waste the parents' time. I think it's a really good mechanism. The other thing that's really good about mediation is the whole IEP team is not there. Often when you're trying to get things done legally in an IEP setting, I don't need the physical therapist there and the music therapist and the counselor and the football coach and the special education teacher and the case manager and 15 principals. Sometimes the more people you have in the meeting, less work gets done. So I like that aspect of it. So that is mediation. So then you write up the mediation agreement, so that goes into the student's cumulative folder, right? So after the mediation, we're still going to have to convene an IEP meeting, right? And to implement the agreements that are in the mediation, right? So it's not like that's a secret, but that goes into the cumulative folder. When you get back to the IEP meeting, we're not having a conversation about it again. We're not arguing about it again. This is what's going into the IEP document. That's really a great mechanism. Usually a mediated settlement is somewhere between, it's usually for an instructional year, a school year. It doesn't go on and on and on and on, okay? All right, the next option of your 4 state dispute resolution options. So again, your state dispute resolution options are what? State IEP facilitation, mediation, a state complaint, and due process. So we're going to talk next, number 3, a state complaint. And so a state complaint is a written complaint. It's not voluntary, that is completed by the parent or the representative. I'm almost always the complainant for my clients. They provide me a notarized release. And so the state complaint is used to investigate alleged violations of special education requirements relating to one or more students. So alleged state special education violations relating to one or more students. And I'm not going to completely unpack all of that, but state complaints are really effective in a number of ways. One of the great ways they're effective is that they're open and closed within 60 days. Open and closed within 60 days. So today is, what is today? Today is June 23rd, 2025. So if today I filed a state complaint with Texas, it would be completed within 60 days. So it would be done by August 23rd, 2025. I like that. It doesn't drag on. It doesn't go on and on. Something else kind of about the mediation we were talking about before. When you agree to mediation, it could be months before you get to the mediation table. Why? Because the school district has to be available, the parent has to be available, the advocate has to be available, the school district's counsel has to be available, and the mediator has to be available. So there's not a million mediators for the state, so that still could be many months out. So when I file a state written complaint, I better know what the federal law is. I better know what the federal law is. And somebody said, can I do a state complaint for a charter school? You can, okay? So when I file a state complaint, I file under federal statutes, because no state has the right to reduce the benefit of IDEA. No state has the right to reduce the benefit of IDEA. So these federal laws are federal, and everybody has to abide by the same state federal regulations. Now, do a state have different administrative codes that go around them? Absolutely. But when I file a complaint, like I will file a complaint that the IEP is not being implemented. So that's 300.323. So I will file that federal complaint, and then I will make sure that I have supported that with facts around that complaint. So who can request a state written complaint? Any person or organization may file a signed written request with the state education agency, or in your state, it might be called the Department of Education. And again, all states have these forms on their websites that you can complete. When and why would a state complaint be requested? To request an investigation of alleged violations of special education requirements. This is the only dispute resolution option open to any person or organization, including those unrelated to the student. So as I'm not related to my clients that I serve, and I'm still able to file that as long as I have consent filed by the parent. Now, teachers will often reach out to us, and we love teachers. God bless teachers. We know that you guys do it for the money and the superstardom, right? We'll have teachers that email us daily. Hey, I'm in ABC School District in Yahoo State, and this has been going on all year. What can I do about it? Can I file a state complaint? You could file a state complaint. I would assume, though, that would probably put your job in jeopardy, so I would never want that to happen for you. When people reach out to us and ask that, I just say, do you have a teachers union? Of course, go to your leadership. Obviously, your leadership should be protecting your certification, because when we ask teachers to participate in stuff that's not legal, that does fall under a state violation of educator misconduct. So somebody's asking, where can I find specific language around this? So this is just a TEA options to resolve disagreements. So this is on the Texas Education Agency. So I would just type in, Florida Department of Education, dispute resolution options, state complaint. You can always just call your state and say, do you have guidance or guidelines around state dispute options, right? Those 4 options: IEP facilitation, mediation, state written complaint, and due process. And every state that I've ever worked with has these guidance. Okay. And is it kept confidential? Is the state education written complaint kept confidential? The state's written findings are subject to release with identifiable information removed. So if I'm the complainant, if I didn't get, I could be the complainant for, Michael Smith, but if I didn't get a consent signed from his parent, that information will go to the parent, but not to me. So I make sure that is consent that I have prior. But with, it's a state record after that. So if you wanted to file with your state to do an open records request and say, hey, I know that at Yahoo Elementary School, there was a state complaint about, not implementing related services for speech language therapy, you could get that through an open records request. Okay. And so the fourth option, and I do a lot of state written complaints, but you've got to know what you're doing. You've got to know what you're doing. Did I say you have to know what you're doing? Yes. And if you guys have questions, there's an orange tab at the bottom. You can send us a question that'll go straight to our office and we'll get that answered for you. Okay. Due process hearing. So the due process hearing is your 4th state dispute option. So the due process hearing, I like to describe as a fist fight. And why do I use that? Because that's what it is. Because if you go to due process, it's going to feel like that. No, in my opinion, nobody wins. It can be very polarizing. However, often it's the only mechanism that the parent has against a school district. But you have to know, as a parent, if you do go to due process hearing, you may hear really unlovely stuff about yourself. You may hear really unlovely stuff about your student. So you have to be fully prepared when you're going into administrative hearing, because that is a court setting. Okay. So what is the purpose of a due process hearing? So a due process hearing is a formal way for parents and for school districts to resolve disagreements about a student's special education and or related service. So, what's important to know about a due process hearing is it's not voluntary. So when a school district or a parent files a due process hearing, it's not voluntary. Hey, Karen, somebody filed a due process against you. If you'd like to show up, you can. It doesn't work that way. So I'm going to, hang on just a second. I need to fix this. Hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change, we're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody.